We are starting now the second session, and I'm glad to introduce Avihay Dorfman from Tel Aviv University, who is presenting us Poverty and Private Law Beyond Distributive Justice. Thank you, and you have 45 minutes for your exposition.
Okay, thank you very much. Thank you very much for the organizing. I think it's a really terrific event, and I'm really happy to meet you all in person. That's my first time talking on real TV and live, but in any event, the paper co-authored with Hanoch Dagan, a colleague of mine in Tel Aviv University, is about, asks the question of what private law could and should do about poverty. It's not about inequality, it's about poverty. And so let me walk you through the basic steps of the argument. So the first step of the argument is trying to identify what's missing or what went wrong in the debates in the scholarship in private law theory up to this point with respect to poverty. And it seems to us that poverty has figured mainly as a question of distributive justice in private law. And once poverty is identified as a problem of distributive injustice, it means that now the debate has been about whether private law could and should accommodate poverty in its various bodies, areas. And so whether it could, so there are some arguments that there is something about the structure of private law that does not allow any systematic pursuit of distributive justice, right? Many of the interactions are kind of anecdotal, and it's really hard to replicate and make the redistribution of resources, opportunities in a regular, normal, ordinary way. And so there is a kind of institutional constraint, and the question is whether private law could do the work, and there are some skepticism on this point. And then there is the question about, again, private law and distributive justice, whether private law should engage in redistribution of resources or opportunities. And the should question here comes from the idea that perhaps what we should do in private law is not so much engage in the question of fairness in the overall allocation of resources in society, but rather it's more about the transactional fairness of the interaction between a person and another person in a contract, in torts, in property, and other areas in private law. And so, but notice that's the interesting stuff here, is that we argue that's the first step in the argument, that this debate is inadequately framed, because once you identify distributive poverty with distributive justice, then it means that the debate is only about whether private law could and should accommodate poverty. What we argue here, and the reason why I think the debate here is inadequately framed, is because poverty also has a relational dimension to it. It cannot be reduced into the question of distributive justice, that we define it. The distributive justice question is, again, fairness in the allocation of resources in a society or even beyond society. But the argument here is that there is something relational as well in connection with poverty. And so once you think seriously about the one-to-one interaction in private law, then the question of poverty can be asked, can be addressed without necessarily speaking about distributive justice. And so we argue that if we think about private law in terms of relational justice, and I'll say what relational justice is and in what ways it departs from corrective justice, then it seems that the question of poverty in private law is alive and well, in a sense that we should understand that poverty should in some way be baked into the terms of the interaction, at least in some situations. So we argue that poverty is just another social condition that should merit accommodation, like physical disability and certain other conditions. And so this is the place in which we deploy the idea of relational justice. And relational justice is an idea about transactional justice. It's not about distributive justice. It's about justice in the terms of interaction between A and B. It departs from corrective justice in the sense that we take it that the right way to think about freedom and equality is not in terms of independence and formal equality, as Kantians would have it, but rather in terms of freedom as autonomy, the idea that we all have the right to write and rewrite our own life story, and about substantive equality rather than formal equality. And by substantive equality, we mean that we should treat parties in the interaction as equals, in a sense that we should take difference seriously, as opposed to disregard differences, at least the relevant differences between the parties. And so from the relational justice point of view, poverty, as I said before, is just another social condition that we should take into account when we figure out how to fix the terms of the interaction between parties. Now, you may ask, well, what do we mean by poverty? And that's a crucial part of the paper, is to try to distinguish between two different conceptions of poverty. We can think about poverty in terms of material deprivation. This is the kind of an absolutist version of equality that we see in many developing countries and in the US, in which we measure poverty in terms of whether you have sufficient food, water, housing, so that you could survive. That's one way to think about poverty. There's another way, one that we find already in Adam Smith's account of poverty, which is poverty as social exclusion. The idea that sometimes you may not be able to interact with dignity with another person. So it's not about the material deprivation per se, but rather it's about whether you could join all those kind of commercial social activities that we have in life. And so we find some basis in Adam Smith's idea of poverty as social exclusion. Of course, we don't buy into his entire argument, but we just take some of those insights that we can think about poverty as social exclusion, and that fits very well, I think, the idea of relational justice. And the way that we try to kind of invite you into our view is to begin with a physical disability as opposed to poverty. But the idea here would be to say that physical disability and poverty are just two different social conditions that should figure prominently in private law. And so we begin with physical disability because we do think that intuitively we do have, or certain people, certain private persons, businesses, should have private responsibility to accommodate the condition of the physically disabled person. And so, for example, if a business organization refuses to accommodate their structure so that their building, so that physically disabled employees or clients would be able to enter, we think that this is a transactional barrier, right? It's not a story, or not necessarily a story, about how the state would allocate resources in a fair way. It could be this, but it's also something that stands in between the one-to-one interaction between the owner and those who try to enter the place. And so once we think about poverty as social exclusion, then we argue that the same idea, not the same situation, but the same idea about transactional barriers could be useful to think or to rethink our approach to private law and poverty, so that just as certain figures in private law would have private responsibility to accommodate the terms of interaction, so that we could include certain people, such as physically disabled persons, some of that argument could also apply in the case of poverty. And so we use the physical disability example to say that, and this is again another way to intervene with traditional debates about poverty in private law, to say that the theoretical, the abstract question of whether poverty can be integrated into private law is not so much a theoretical question. It's not about a question of principle, in a sense that we now think that no one would argue that private law should not impose some duties of accommodation on, let's say, commercial entities to accommodate physically disabled persons. I know that there are some folks that may say that no, private law should never commandeer the support of those people, but in as much as I think our intuitions are that certain business owners and some other entities in private law should have and do have, in fact, private responsibility towards physically disabled persons. If you buy that part of the argument and then, and that's the next stage, you think that poverty is another case of social exclusion, then we think that we should open up the floor to discuss whether we should accommodate poverty. And again, the question is not so much a theoretical question, but it's more about the operational constraints. How far can we go in private law and impose duties of accommodation in the case of poverty? And so we want to relocate the question. If, before we kind of intervene in the literature, the problem with poverty was whether distributive justice could be part of private law, we answer, no, that's not the right question. The question is whether poverty has a relational dimension, and if so, and we answer that it does have, then the question is not so much whether we should accommodate it. Remember that relational justice thinks about substantive equality and autonomy, not about independence and formal equality. So it seems that the real question where the real action is more about the operational constraints. It's about how we could accommodate poverty, given that there are some, I won't say distinct, but there are some special constraints, some special challenges that come with accommodating poverty, right? Sometimes if you want to accommodate poverty, that could be demeaning, that would be demanding, right? So there are some constraints that operate in this situation, and so private law and those who are judges, regulators, legislators, who are in the business of deciding what kind of duties of accommodation we should have, should take into account those operational constraints. And so we make a distinction between direct and indirect accommodation. Sometimes accommodating poverty is not demeaning, is not too demanding, does not have some kind of epistemical challenges. So we give the examples of affordable education in private institutions, affordable legal services, and here I'll use the affordable legal services as an example to make a broader point. When we talk about private responsibility, we make a distinction between a situation in which a private entity has an incentive or some other economic interest to accommodate, right? So some pro bono services may be explained by some kind of ethical or some other reputational concerns on the part of the person who provides those services. We argue differently. We argue that part of what it means to do relational justice is that those who provide those services are duty bound, right? We want private law to mandate this kind of responsibility. So there has to be a duty, not just an incentive to do so. And so some cases such as affordable universities, affordable education, affordable legal services, affordable houses, may be cases in which we could use direct accommodation because we think the operational constraints are not as challenging as they are in other contexts. And so we move from direct accommodation to indirect accommodation, situations in which we think it's against the rule of law to impose a duty of accommodation to try to tailor accommodation based on the specifics of the transaction. We think that that's inimical to the way in which we move from morality to legality. I think at the first presentation by Larissa, we already noticed that there may be some tensions when we move from morality to legality. The way in which, in this paper, we try to think about the transition from morality to legality is to take seriously the rule of law and the idea that you cannot use ad hoc, individualized judgments as we try to understand terms of interaction in private law. And so the indirect accommodation is a way to address that problem. And so we give some examples to those indirect accommodation. We call it structural accommodation because it's part of the structure of the interaction. So we give 4 different examples. Let me just go over one of them to explain exactly how it works and how it kind of helps to tease out what's distinctive about relational justice and how relational justice kind of conceives the idea, the problem of poverty, and in what ways it differs from both, I would say, corrective justice and distributive justice. So think about the example of minimum wage, or we could call it living wage. But the idea is this. We could impose duties on employers to accommodate, let's say, religious affiliation and many other conditions, personal social conditions of the employee, right? The question with minimum wage is whether we should accommodate poverty, whether we should alleviate poverty by imposing a duty of minimum wage on the employer. We think that, and this is how we kind of distinguish relational justice from distributive justice. From a point of view of distributive justice, it is not that clear that we should have this kind of minimum wage requirement. There's an empirical debate among economists about the consequences of minimum wage. Some would say that it has some regressive implications because once you kind of put minimum wage, that may force employers to hire less, those who really need the money, right? So it's not that clear whether from a distributive justice you have to have a minimum wage mandate. From the corrective justice point of view, it's not clear at all, I would say. What was the justification to impose a duty on the employer, unless, of course, you tell a story that the employer is not really a private entity, but you just the employer is a kind of a quasi-public official, and we employ that employer in the service of doing distributive justice or something like that. But as a private individual, it's not that clear whether independence and formal equality could even account for the situation. I won't go further, but it seems that that's a kind of a huge problem with the corrective justice idea that if you cannot really understand the substantial inequality between employees and employer, it seems that you lose the debate even before it even begins, because the problem here is that, of course, there is, at least in most cases, a huge asymmetry between employer and employee. And so relational justice wants to say that we have to have a duty on the part of the employer to provide minimum wage. It's not so much about the distributive consequences. In fact, we are willing to concede that it might carry some regressive implications, right? We are not indifferent to that, of course. We want the state to take care for that, but we think that in terms of the justice, the fairness of the interaction between the employer and employee, that's the one-to-one interaction. Part of what it means to respect the employee is not just to accommodate his or her religious affiliation, familiar obligations, and certain others, but it also to pay a sufficiently good amount of money. Now, of course, we cannot do the mathematics. I don't know what the algorithm would be and what should be the number. That's not the point. The point is it has to come in the form of a duty to accommodate or to alleviate poverty by way of imposing this duty of minimum wage. And so we could justify it in terms of autonomy and substantive equality. And so we think that that's another case in which we could see how structural, indirect accommodation of poverty works, right? So we are not asking a question about the specifics of that employer or this employer or that employee and this employee. It's not an individualized ad hoc judgment made ex post by a court, but rather it's a way to frame ex ante, to construct a framework of just interactions between employers and employee, and that we think a way to overcome the operational constraints of accommodating poverty in private law. So we use some other examples such as price control, some as fair access to credit markets and housing as other examples in which we could say that in all those voluntary interactions, part of what it means to interact with fairness, to abide by the dictates of relational justice, which is autonomy and substantive equality. Part of what it means to do so is that there should be private responsibility to accommodating poverty. And of course, we do have some kind of limitations or ways to mitigate the burden, and I would stop with just saying two things. One, the duty to accommodate poverty is does not demand utmost care. It's not that we ask from, let's say, employers to do everything that they can, but rather it's only about reasonable accommodation. Just as we see in the case of physical disabilities and other social conditions, it's a duty of reasonable, not utmost accommodation. So we have to take into account some of the predicament of engaging in this accommodation. That's the first point. The other point here is that part of what it means to think about those interactions in terms of relational justice is that we ought to take into account not just the interest of the person who should be the beneficiary of the accommodation, but also the person who has the duty to make accommodation. And so part of the reason why we only argue for reasonable accommodation is that we want to take seriously also the autonomy interest of the employer in this case or other persons. And so the point here is not to shut down their businesses, but rather to allow them to operate with this kind of site constraint, which is to accommodate poverty. Thank you very much.